You know how sometimes a seemingly small neighborhood issue, like a new hot tub, can just explode? Well, that's exactly what happened here. What started as a simple privacy complaint spiraled into a full-blown, honest-to-goodness legal battle. We're going to break down the entire court case from start to finish.
So that's the big question, right? You've got one homeowner who feels like his privacy has been totally violated. You've got his neighbors who probably just want to relax in their new spa. And then, stuck right in the middle, you have the Homeowners Association. It seems pretty simple on the surface, but as you're about to see, the real answer is buried in the details.
So where did this whole mess begin? Well, like a lot of these neighborhood dramas, it all kicked off with a single complaint. One person saw something they didn't like, and they decided to put it in writing.
Okay, so picture this. You're homeowner Erik Pierce, and you look out your window, and you can see your neighbors, the Kinstles family, hanging out in their hot tub. Not only that, but you feel like they can look right back into your house. For him, this was a major invasion of privacy, and he wasn't having it.
All right, to keep all this straight, let's do a quick roll call. Erik Pierce is the petitioner. He's the one who filed the complaint. The respondent is the Morado Community Association. That's the HOA. And the whole reason we're here? The Kinstles family's hot tub. Now that we know who's who, let's dig into the rule book.
Every HOA has its own Bible, so to speak, and in this case, the entire fight hangs on the exact wording in a document called the CC&Rs, that stands for Covenants, Conditions, and Restrictions.
Basically, you can think of the CC&Rs as the constitution for the neighborhood. It's the document that lays out all the rules, from what color you can paint your front door to, you guessed it, whether you can even have a hot tub in your backyard.
Okay, I know this is a bunch of dense legal text, but stick with me. This is the exact rule, Section 4.27. The key phrase here, the one that this whole case is about, is that neither the hot tub nor its occupants are visible from neighboring property. Seems pretty black and white, right?
So let's just cut through the legalese. Here's what it boils down to. You can have a hot tub, but, and this is a big but, it has to be properly screened and the HOA has to approve it first. But the absolute most important rule for our story, nobody should be able to see the tub or the people in it, period. So, Mr. Pierce files his complaint pointing right to that rule. You'd think that would be the end of it, but nope. Instead of a quick fix, things just got more and more complicated. This timeline really shows how it all snowballed. So it all starts in September 2019. By February 2020, the HOA approves the hot tub, but only if screening is built. Then, just a month later, they tell Mr. Pierce the case is closed, even though there's still no screen. He felt like the HOA just wasn't doing its job, so he took the next step and filed with the state. And that's what led to the big hearing in January 2021.
And this brings us to the main event, the formal hearing. This is where both sides got to stand up in front of a judge, under oath, and tell their side of the story.
When you boil it all down, their arguments were pretty different. Mr. Pierce's case was super straightforward. Hey, there's a rule, you told them to build a screen, and they didn't. Enforce your own rules. The HOA's defense, though, was a little more nuanced. They basically said, look, we have the right to enforce the rules, but we also have the discretion to decide when and how. And because of the lawsuit, we chose to wait.
And just to add another little wrinkle to the story, it turns out there was some confusion inside the HOA itself. The old community manager actually testified that she thought the family had a 6-month grace period to get the screen built. The problem? She couldn't actually point to any rule in the book that said that. Oops. So after all the testimony, all the evidence, all the back and forth, it was finally time for the administrative law judge, Adam D. Stone, to make the call. All right, this is the moment of truth. What do you think? On one side, you have a homeowner with a very clear rule on his side. On the other, you have an HOA claiming it had the right to wait. Who do you think the judge sided with?
And here it is, the final decision. Petition denied. Mr. Pierce, the homeowner who started this whole thing, lost his case against the HOA. I bet that's not what most of you were expecting.
Right? I know what you're thinking. How is that possible? The judge literally agreed that the screen hadn't been built. The neighbors were clearly in violation of the HOA's condition. So how on earth did the HOA walk away the winner here?
Well, this is where the whole case takes a sharp turn, because the deciding factor, the thing that swung the entire verdict, wasn't the rule about hot tubs. No, it was a completely different section of the rulebook, the part about enforcement.
And there it is. That one sentence from the judge's decision explains everything. He pointed out that the rules gave the HOA board a right to enforce the rules, but not an absolute obligation to do it immediately. That's a huge difference.
So the key takeaway, the whole shebang, is this distinction between discretionary power and mandatory power. The HOA could have acted, but it wasn't required to act on any specific timeline. They had the wiggle room to choose their approach.
So what does this all mean? Well, it means the HOA was legally covered. The judge decided that their reason for waiting, because of the active lawsuit and hoping the neighbors would sort it out, was a perfectly reasonable use of that discretionary power. At the end of the day, by choosing when to act, they hadn't actually broken any of their own rules.
And that really leaves us with one final big question. This whole case proves that the most obvious rule isn't always the one that decides the fight. It really makes you wonder, doesn't it? What's buried in the fine print of your community's rulebook? Do you know the difference between what your HOA has a right to do and what it actually has an obligation to do?